moving on here to the legal bases for processing, and this is one of the questions that I get asked about most when I'm talking about the general data regulation to people, to organisations and researchers in the UK. They want to know about the lawful basis for processing. So you have to have a lawful basis for processing, and you have to be under the transparency and accountability requirements of the GDPR. You have to be very clear about what that lawful basis is. The general lawful bases are found in Article 6 of the Act, and there are 6 of these. They're not particularly specific. They're quite general, really, and they can apply to lots of different contexts and lots of different situations. One of the things that's quite interesting from the research perspective is that consent is often put on a pedestal, and I think particularly in the context of biobanking research, it historically has been the basis for a lot of processing of personal data. Even though you don't currently need to publish the legal basis, clearly most legitimate research outfits do have a legal basis in mind where they are processing personal data. But the policy position in the UK is currently that where an organisation has, as part of its requirement, or is allowed to perform research, that research could be done in the public interest or in the exercise of its official authority. And in the UK, hospitals and NHS organisations and universities are seeing as doing research as part of their official authority. So where they're processing data for research, they don't need to necessarily rely on consent as the lawful basis for that, because they can do this, they can process that data, that personal data anyway, on the basis of public interest or on the basis of the fact that it's in their official authority to do so. This only applies to 2 public authorities. It doesn't apply to charitable institutions or pharmaceutical companies. Now, they would have to rely on a different lawful basis to process personal data for research purposes. And again, the policy position seems to be that they're guided to use legitimate interests as their basis for lawful processing. This does require them to do a little bit more than public authorities are required to do under their official authority, because the legitimate interest grounds does require you to demonstrate why you need to process that data for those interests, and to show that it doesn't actually interfere with the data subject's fundamental rights and freedoms. That's not the end of lawful basis, because if you're processing a special category of personal data, then you also need to fulfill one of the conditions in Article 9. And because health research is often processing data about health, the organisations and researchers who are processing that data will also need to ensure that they have a condition for processing special category of personal data under Article 9. And what Article 9 does, it generally, is prohibits the processing of this type of data, the special categories of personal data, unless one of 10 conditions applies. So we can see here that genetic and biometric data and health data both fall within special categories of personal data. Now, I haven't listed all of the 10 conditions here. I've particularly focused on 2 conditions that I think are important in the context of processing data for the purposes of scientific research. And historically, like I said, I think that what's been particularly important in processing special categories of health data has been the explicit consent of the data subject. However, we know that the GDPR provides a new ground for processing special categories of personal data, and this is under Article 9.2j, and this is where the processing is necessary for archiving purposes or scientific or historical purposes. Okay, now we often refer to this Article 9.2j as the research exemption. But what you need to do if you want to rely on this exemption, what becomes very important is Article 89.1, because if you want to rely on the research exemption under Article 89, then you can only do that if you can show that your processing is in accordance with Article 89.1 and the safeguards in Article 89.1. What I've written here is an exact reproduction of Article 89.1, so sorry it's such a wordy slide. But what's particularly important here is that the organisation and the researchers have in place the technical and organisational measures to ensure the respect for the principle of data minimisation. So this is generally about how systems are set up to manage the use of personal data in research. Significant derogation. So what do data controllers need to do in order to show that they are demonstrate their legal basis, their lawful basis for processing? Well, they need to publish this, and this should be clear in the privacy notice exactly what the lawful basis for processing is. And this is a new requirement. So many people are currently making amendments to their privacy notices in order to reflect to data subjects what their lawful basis for processing is.